attorney knows and works well with the other attorney. Because, see, if the two attorneys know each other well enough, then when one attorney is saying, hey, this is my argument, and here's why this is the argument I've made, the other attorney is going to be open to listening to that, right? And you very well may be able to have a negotiated agreement instead of having to go to trial with the court. And I say that because, once again, as we talked about in the last session, people automatically assume that what they see on the TV is the case. You see on the TV, Sam Waterston hand somebody a blue piece of paper, and they're like, well, I'll see here's my motion, and I'll see you in court on that issue. Okay, that's not what goes on, right? So we file a motion, right? And then we'll set a hearing date for that motion. But guess what? You need to have your balance paid and some more money in the retainer for that. Oh, you want to do trial? Trial is not like, it's just we're going to just show up and make an argument. No. If you argue without your preparation for court, that's called malpractice. So you've got all the behind-the-scenes stuff you got to pay for, the depositions, the subpoenas, the reviewing of your file, the review of the case law, the legal research, the lawyer who stays up all night, preparing and writing out the questions for, cross-examination and for direct examination and all of this, and preparing for exceptions to objections and all these different kind of things. Long story short, you're talking about thousands and thousands and thousands of dollars. And a lot of time and a lot of emotional energy. If you have two attorneys who know each other and who respect each other, right, then those attorneys can be upfront. And a lot of times we can agree and stipulate to things like extensions of time for exchanging, financial records, what we call discovery. A lot of times we can literally have a civil interaction in mediation. Every court case ends up on a mediation. But we have a civil interaction in mediation, and maybe can help our clients come to a resolution. Because we've already been able to discuss the merits of the case with each other. That's the other thing. People think, you surprised the case with the Matlock or with the, I don't know who's the other guy who used to always come out and be like, let me throw the ball to you. You're saying you witnessed this. Let me throw the ball. And, you missed it. Why? Because you're supposed to be wearing gloves. No, it doesn't happen like that. There is no gotcha moment. As a matter of fact, it's expressly forbidden in the rules for you to do what's called trial by fire, or trial by surprise. You have to have exchanges. Matter of fact, let's say if there's evidence that you're going to use, you got to show that to the other side long before you ever get a chance to put it into evidence or try to put it into evidence for the court. And that's so funny to me. That's what they're expecting. They'll give me stuff and say, hey, don't show this to the other side. Well, I have to.
Is this one guy on
evidence?
Is this other guy on YouTube? He has a YouTube channel called Legal Eagle. I watch his channel all the time because he always he'll do a episode on what the first one I saw he did was on how would Batman be charged if he was a real person. How would the law go after him? It was really interesting. I like to watch it.
We've gotten completely, we went all the way to law and completely off topic about love. That is so hilarious to me.
No, because we're talking about, relationships and from a legal standpoint.
I love it.
That's what this episode was supposed to be about.
Okay.
Yeah, relationships through a legal standpoint. Because like I said, we just interviewed her cousin who was in the politics. So that episode is about relationships, a political standpoint between the black community and politicians. So we're doing exactly what this episode was about.
Okay, so we're good.
Yeah,
I just wanted to be sure that I'm not getting you off track and so forth and so on, because we will.
No, this is like my 4th interview. So I'm learning how to, float like a butterfly and sting like a bee. I'm learning as I'm going, but I know how to keep us on track.
I am so freaking proud of you.
Thank you. I appreciate it. In your professional opinion, how important has sex seemed to be a topic when coming to divorce?
In my professional opinion?
Yeah. Do you see people saying this is a part of the reason why I'm getting a divorce?
I see it more so when the other side is having sex with someone else, that's the reason that they're getting divorced. A lot of times it's like, no, we're not sleeping together. We haven't been intimate because of other issues. You know, I am always surprised at the number of parties that I've run across, you know, who aren't sleeping together, who haven't slept together because of other issues even, but haven't slept together in years.
Do you find that in most cases it's always that one person who still wants to try and keep the marriage together like in movies, and it's just that other person who's just like, no, I'm done? Or is it usually like by the time people come to you or ready to get a divorce, both parties are done?
I don't even know if it's so much. I don't. So every once in a while, I'll run across people who want to get or who are getting a divorce, and the other party wants to stay married, right? And I say that because of my experience as an attorney, but also as my experience as a mediator, right? So when I'm the attorney for my client, I can do things, I can communicate differently than I would if I was the mediator of a case, right? Because as a mediator, I'm neutral, I'm unbiased, and so forth. But as an attorney, I can talk to my client, and I always let my clients know, if you are not sure that you want to get a divorce, don't do it. Because I have the benefit of having been through a divorce. So going back, I guess we go round robin and circle, but in answering another one of your questions, you know, typically when the typical law student, the typical lawyer goes through, you know, high school straight to 4 years of undergrad, and then to 3 years of law school, they hop out, they take the bar, they hop out, they're practicing law. So that means that they're 24, 25 years old taking on cases. So a lot of times they don't have life experience behind, you know, the areas that they practice in, right? I have the benefit, the detriment, but the benefit now of having gone through, you know, a divorce. I represented myself in my own divorce, and this was well before I ever thought about going to law school. Many years before I ever thought about going to law school or being an attorney. You know, and I've lived life well before becoming an attorney because I didn't go to law school until I was, you know, middle-aged. So why am I saying all this? I'm saying all this because when I talk with my clients, my divorce clients, I'm always very clear. Do this because you've done everything else and you are done. That is one of the questions that we have to ask. Is your marriage irretrievably broken? No amount of counseling or conversation or communication can resolve any of these issues to help you stay married. And I want my clients to be able to say indubitably, without a doubt, the answer is, yes, my marriage is irretrievably broken and nothing else can save it. And that means that, you know, I always ask my clients, are you done? If you are not sure that you're done, right? Give it 100%. Because if not, they're always going to have the what if. And I know that because that's what I experienced. So I'm able to use my detriment to their benefit.
That's what's up. Now, you know, as a society, we often hear men complaining about child support, even though we know that men and women are on child support. But how is it easier to get joint or full custody of your child when you're married as opposed to just having a baby mama or baby daddy?
No, it's not easier or harder. It's the same. I think the issue is that, or the fact is when a child is born of a marriage, it's automatically presumed that that's that father's child, or that's that. Now, you know, thanks to Obergefell, the case law Obergefell from the Supreme Court, now, you know, same-sex couples can be married. So when a child is born in that marriage, most likely there's automatically the assumption that that child is born of the marriage of both parents, both married people are that child's parents. Right? Whereas if the child is born and the couple is not married, then there's things that the father, the biological father, has to do to prove paternity. Okay? It's not harder or more difficult. The issue is that when a married couple gets divorced, that's automatically on the table. When a non-married couple, they break up, that's not automatically on the table. You have to still go and put in a paternity case. Years ago, generations ago, there was the thought that mamas are the best choices for the babies. There's the tender years. You know, these young kids need to be with mom.
Yeah.
Now, these kids need both parents.
Love it.
Right? But people don't realize that. There's these old wives' tales of what they tell each other.
Yeah. I mean, you like you said, you know, back in the day, I think a lot of people are still going by what happened back in the day. So I think people need to educate themselves, because I hear a lot of brothers say that, oh, they just going to give it to the mama anyway. Go do your research, fellas.
Right.
That's all I'm going to say.
Go and do a consultation, because, you know what, it's funny, but I've seen a lot of cases where the courts look at this and they're like, you know what? Really? This child should spend majority of time with that.
I remember when, when Cece was born, I took off 2 months paid leave of paternity leave. You know, so fellas, get your stuff right.
Absolutely, and I have to stick this out. I say this often. I know we talk about this often. I keep saying this. Fathers, if you're unmarried when mom has the baby, mom automatically is the natural guardian of the child.
Okay.
They saw the baby come out of mama, so mom is automatically the natural guardian of the child. Mm-hmm. Mom automatically has, parental rights. Mom already has parental responsibility. Mm. You have none of those things for purposes of an immediate right to make decisions for your child, an immediate right to have your child overnight and so forth. Yeah, no, you don't. Mm. So you need to step up and make sure to say, hey, this is what I'm trying to do, because the court won't come after you. They will come after you for child support, right? But that's a whole other administrative court process through the state, yada, 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 yada. And we can talk about it if you want to, but they will come after you for child support. And you can be on child support and still have no rights to come and pick up your children, spend time with them, keep them with you, whatever.
Get your game right, fellas. I can't stress that enough. Get your game right. Why aren't prenups mandatory? And should all couples have them?
Ooh. All right, I'm gonna step on some toes. I know this. Prenups are not mandatory. So first off, just for your audience, let's explain what a prenuptial agreement is. A prenuptial agreement is an agreement that is a contract that is written that the parties are on into before they get married. It basically lays out exactly what's going to happen with the property, whether it's non-marital property or marital property, in the event of a divorce or in the event of death. Mm-hmm. That's also really important to know, right? Mm-hmm. It is done before the parties get married. There are certain ways that it needs to be done in order for it to be effective and to be enforceable, but it can make the difference. So that's what a prenup is when we're talking about a prenup. It's giving you that. There's also something called a postnup that can be done if it's, after you all have gotten married as well. Now you're asking me, why are they not mandatory, or should they be mandatory?
Why aren't they mandatory? I don't care you feel they should be or not. I do. Why aren't they mandatory? And should all couples, be it they have money or not, get prenups when they get married?
Okay. They're not mandatory because in the state of Florida, constitutionally, everybody has a right to enter into a contract or an agreement, even if it's a bad contract or an agreement. Keep in mind that marriage is a contract. The very act of getting married is a contract. When you are saying those vows, that is a verbal contract, right? When you all sign the license and you have your marriage certificate, that is a written memorialization of your contract. So people don't realize that, right? At the state of Florida, you're allowed to get into a contract even if it's a bad contract. Meaning even if it's stupid terms, you're allowed to do that. As long as it doesn't, as long as it's not against like public policy. Yeah. So that's why they can control if you're marrying, your sibling. Like you and I can never get married. Okay. Amen. Let's take a moment of silence. Thank God for that. Yes. But you can't marry your pet or whatever. Okay. But it's a contract. That's why they can't force you to get into a prenuptial agreement, because you can make good contracts, you can make bad contracts, and not having a prenuptial agreement is up to you to determine whether that's a good contract or a bad contract. Now, your second part of your question,
should all couples have them?
That's a hard question. question to ask or to answer. And the reason I say that is